Hello, I'm David Mandell, one of the principals of the OJM Group, and I appreciate you taking the time to watch this short video on ViewMedi. Obviously, we have many videos on our channel, and I encourage you to watch others in addition to this one today. For those of you who haven't gotten our materials, we have many books we've written for physicians over the years, some for particular specialties like dermatologists and orthopedic surgeons, some for different states, and of course our national flagship book for doctors only, which is a version of a book that we've really had for physicians for almost 20 years, which we update regularly. And I encourage you as a ViewMedi member to get any of these books that you'd like. We have them in hard copy, also in Kindle and iPad version. And at the end, I'll tell you how you can get these. So today I'm really diving into a particular topic that comes under the heading of asset protection. And as I mentioned, we have a number of different videos on ViewMedi, including one, Asset Protection 101, and a couple of others that I've done on that topic. I highly recommend you listen to a couple of those others because they put what I'm talking about today in context. So what am I talking about today? I'm talking about limited liability companies called LLCs or family limited partnerships called FLPs. These are legal entities, legal tools that you can set up in any state, although there are some states that are really advantageous, that have a number of different benefits to them if done and maintained properly. And physicians have used them for decades, and I've helped physicians as an attorney use them for almost 20 years now for a number of different reasons. Family wealth planning. These are terrific tools to put some formality around building wealth, and families have done this for decades when trying to get other family members involved, when trying to get perhaps discounts by aggregating family assets from investment managers or other type of providers, and providing a method for which you can do gifting and make gifts to children or grandchildren, other family members, without giving up control, without giving them access to any cash or other types of assets. So these tools are very valuable in a long-range estate planning, gift planning, and family wealth planning context. But today we're really talking about them in context of asset protection planning. Because if done properly and maintained properly, limited liability companies and family limited partnerships provide a high level of asset protection, lawsuit protection, for assets that are owned inside of them. Now, when we talk about asset protection, we have to differ between inside and outside protection. We do this in our books in a significant way. But just at a really high level, inside protection is being concerned with the risks that an asset or a business has because of the operations of that business or that asset. As an example, real estate. Real estate we consider a dangerous asset because it can create liability, from slip and falls to claims by renters to claims by visitors, environmental claims. And limited liability companies, much more than limited partnerships, are the standard for owning real estate in this country because if done right, they can isolate that liability inside. So if I'm an investor, passive investor in a real estate project, and I put money into an LLC, I may have a right to profits, I may have a right to losses, I may have a right to inspect the books, but I'm not involved in it, and that LLC is done right, then if there's a claim related to that real estate, I'm protected. My personal assets are not subject to the claims of that real estate, which is owned in a separate LLC. And if you own real estate outside of your home, second homes, rental properties, land, property at your business, you need to have an LLC to be owning those properties, and not every LLC is proper. We'll talk about that in a second. Now, from an outside perspective, outside protection deals with something completely different. This is how do we protect the asset from a claim against one of the owners? So to use an example here, let's talk about your securities portfolio or cash. Those aren't going to create liability. There's no inside risk there. But what you might be concerned about is what happens if there's a malpractice action against me and there's a judgment beyond insurance coverage limits? Or what if there's a car accident against me or my spouse and they have a judgment beyond insurance, or whether there's a claim against me for sexual harassment or something where I may not have any insurance. If someone gets a judgment against me, can they come after my investments? Well, if they owned in your name, if they're owned jointly, then the answer is most likely yes. Those may be 100% or 50% vulnerable to those kinds of claims. And for those reasons, for outside protection reasons, we're often recommending clients have limited partnerships or LLCs to own their investments, their securities, their other assets, their interests in other businesses, so that they have a high level of protection against those types of outside claims. So as you listening here, whether you've done these kind of tools before, or some of your colleagues have, it's pretty common across the spectrum. Now, as I mentioned, this ties into a larger discussion of all of the asset protection tools that are out there. This is a subject of another video which you should watch. But you can see that limited partnerships and LLCs are in the middle of the scale. They're much better than the negative positions, which we designate as places or ownership forms that have total or partial or significant exposure. But they're not as good as the highest levels of protection, like state and federal exemptions. And again, I have another talk on those types of protective assets. So realize that limited partnerships and LLCs are solid tools in the middle of the scale, not going to get you the highest level of protection, but certainly going to be much better than the lowest level of exposure. Now, I've reviewed the work. As a lawyer, I probably created almost 1,000 entities for clients over the years, almost 20 years now that I've been a practicing attorney. As a consultant on the OJM side, and as a lawyer, I've looked at the work of about 200 other law firms, from the largest law firms in the country to solo attorneys that my clients, when they come to me, have already used. Okay? And what I find is most clients have not kept up their formalities. And that's the weakness number one, meaning it doesn't matter how good your agreement is or how solidly you've chosen the right jurisdiction, but if your limited partnership or your LLC is not complied with, if the rules are not respected, if it doesn't have an ongoing maintenance program every year, then you're not going to get that protection, whether inside or outside, that you're looking for. So you have to ask yourself, do I have a limited partnership, do I have an LLC, and do I have an annual compliance program overseen ideally by an attorney that includes member meeting, that includes reports from non-managing members, that includes updates to the operating agreement, partnership agreements by counsel based on new case law that comes down, and even making sure that folks, are current with their registered agent and state filings. One of the things I do at my law firm is I have an annual compliance program where I charge clients to do that and keep a file on it. And just like any patient you would see needs regular checkups to keep up their health, it's the exact same thing with the corporate help of the limited partnership and the LLC. And so many physicians set it up one time and then they forget about it, and then they expect that it's really helping them when it may not be. So that's weakness number one. Weakness number two is more technical. Weakness number one seems probably pretty obvious. If you don't maintain it, if you don't do what you're supposed to do every year, it's not going to give you what you want. But number two is a little more technical, and I don't expect physicians to really know this or even be able to spot it. But the bottom line is, when I look at the work of the 200 or so law firms I've seen around the country, the good news I've been able to, along with my practice and being, on some listservs and in communities with the best asset protection attorneys in the country, I think I've been able to glean out what is the best practices, the top level of language that needs to be in a proper FLP and LLC agreement. That changes over time as well. My agreements that I use today are a little different than they were 5, 10, 15 years ago, and I imagine they will be in another 5 years as we learn more and case law comes down, statutes change. But when I look at the work of the 200 law firms I've seen from clients across the country, very few, I'd say less than 5%, have the best language, have what I consider best practices. And it's not to denigrate any attorney, but most of the folks that when you're using advisors to set up these entities, they're estate planning attorneys, they're real estate attorneys, they're corporate attorneys, they're your friend who's an attorney, they're your brother-in-law who's an attorney, and they don't have, I think, what I have, which is the benefit of seeing the work of 200 law firms and taking the best practices. from that and being on the listserv. So just I imagine in your specialty of medicine, as you listen to this, if you were there and you could see 200 of your colleagues across the country over the last 5 years perform a procedure that you do every day, I think you'd probably come out a much better physician. That's why to go to your CME meetings, that's why you're on top of it. I've had the benefit of doing that. What kind of language do I see missing all the time? Rights of involuntary transferees and language that mirrors charging order rules in the state where the entity has been set up. Pro rata versus non-pro rata distributions, consequences of fraudulent transfers into LLCs or limited partnerships. Language that deals with non-controlling member obligations to make sure that is considered executory versus non-executory contract. A lot of what I just said is probably, just legal mumbo jumbo to you, but from a asset protection attorney's point of view, this is the difference between an LLC and limited partnership that's going to give the best protections to our clients and one that is not. And a lot of the ones I've seen will not. So yeah, it's an LLP, it's an LLC, but it's not protecting the way you think it is. And that can, good news is that can easily be improved by doing amendments, and I do that a lot for clients a lot of the time, is amending their LLC. They don't have to change it. They don't have to get a new tax ID number. It's the same entity they've always had, but they're amending their operating agreement just like you would amend a will to improve it. The third weakness, which is not as common but still exists, is suboptimal jurisdiction, meaning for certain assets, you don't have to set up an LLC or limited partnership in the state where you reside. For certain assets, you do. If your LLC is going to own real estate, it's got to be formed in a state where that real estate exists. But if you have the choice to use an LP or an LLC in a state of any state, maybe because it's going to own securities or cash accounts or other personal property that's not domiciled in one state particularly, then you can use the best jurisdictions. And depending on what you want to use or what you're looking for, Delaware, Nevada, Wyoming, Florida can all be possibilities, as even South Dakota. So just like corporations, multinational corporations will choose Delaware often because of their favorable rules, so can you choose an entity for certain purposes to take advantage of the laws in particular states. And there are, be very clear, there are states that are much more protective of their entities because of not only case law, but the statutes of those states than other states. And oftentimes I see clients who may have a good agreement, may have been keeping it upright, but they don't even have it in the right state. And that's something that easily can be changed with the redomiciling. So I drilled down here very quickly into 3 potential weaknesses that many of you may have in your limited partnerships or LLCs, and if you don't have those, that you should look for to make sure you do right when it's time to put these tools in place. I call them the building blocks of asset protection because most clients will have them as part of their overall wealth protection plan. As we conclude here, I would encourage you to contact us for a free consult, take advantage of the free book, and certainly spend some time on our channel and see more of our videos on ViewMedi. Thank you.
OJM is a unique, multidisciplinary wealth management firm. We specialize in working with physicians, and our team has been helping doctors for over 20 years. In fact, we have worked with over 1,000 physician clients throughout the country. We would welcome the opportunity to speak with you about how we might be able to bring value to your wealth planning. As I mentioned at the outset of this video, we encourage you to request a copy of Wealth Management Made Simple, For Doctors Only, or one of our other books for physicians. Our books are available in hard copy, Kindle, and iPad formats. You can get them all for free by clicking the button below. In addition to a free book, OJM Group also offers ViewMedi members a complimentary consultation, where we can answer your questions and see if our firm might be a good fit for your situation. Simply click the same button below to schedule your free consultation. Enjoy the free copies of our books, and we hope to speak with you soon. Thanks for watching.